May I please, Your Lordships? My Lord, I may be allowed to make a mention. Item number 12 and 13.
13,
12 and 13.
12 and 13.
Yes, my Lord. My Lord, here I am led by one Ndika, who is from the principal seat, and he has some difficulties today. So if this can be fixed on 15th of March,
As a fixed matter,
my Lord,
your name please?
Taka Kichu.
And Takakisu. Learned counsel appearing for the petitioners raised for examination on the ground that the learned English counsel, Mr. N. Deka, who is from Gauhati, is unable to attend court today. So, government side?
Lordship, no objection.
So and so appearing for the Government of Nagaland has no objection. List on 15-3. 15-3?
My Lord. Bless my Lord.
May I please, Your Lordship? I would like to mention item number 3, if it could be listed after 4 weeks for hearing, Your Lordship.
You work for the petitioner
Yes, Your Lordship.
after 3 weeks
4 weeks, Your Lordship.
due to some inconvenience. Huh? After 4 weeks, all right.
Much obliged.
I beg to mention item number 5 also.
At number 5,
Yes.
you work for the
I'm
respondents,
for the respond Union of India.
Union of India,
Come after 3 weeks, Lordship.
after 3 weeks. Hey, you have not filed affidavit, no?
Yes, I have not filed. I have not filed, Lordship.
So, in the meantime, they.
Otherwise, 4 weeks, Lordship.
Huh?
4 weeks. That's
Three,
why
3 or 4 weeks?
4 weeks.
4 weeks. In the meantime, the Union of India shall file their affidavit in opposition, if any. Next.
May I please, Your Lordship? Lordship, I beg to mention item number 19 and 20, Lordship. On
19 and 20.
Lordship, on behalf of KB Angami, Lordship. Lordship, kindly list this matter after 2 weeks, Lordship.
19 and 20.
Lordship,
This is government advocate. Okay, after
after 2 weeks, Lordship.
2 weeks.
Yes,
Any
Your Lordship, I'm
comments?
for the appellant.
You are for the appellant say.
Yes, Your Lordship.
Okay, after 2 weeks.
Yes, I have no objection.
Lordship, I also beg to mention item number 22, Lordship.
Item number
22,
22.
on behalf of Vijimo, Lordship. Kindly list this matter after 2 weeks, Lordship. He is indisposed, Lordship.
No, you have not, the service of notice on the respondent number 2 is still awaited.
Yes, Lordship.
So it cannot be. This, do you want to file objection here? 22. In 22, which just submitted.
Lordship, in this case, I'm appearing on behalf of my colleague, Lordship.
Okay. Then after 1 week or 2 weeks?
After 2 weeks,
After
Lordship.
2 weeks.
He's indisposed, Lordship. Obliged, Lordship.
Your Lordships, I beg to mention item number 7.
Seven.
PIL 20, yes, Your Lordship. If this matter can come up after 2 weeks.
Have you received the instructions?
Lordship, I have already filed my affidavit.
You have
and-
filed affidavit.
Yes, and regarding with the COVID scheme, that has been closed. So now the relief of the petitioner is no more
Your Lordship, we
certified.
got the information that the scheme is still continuing.
No,
So,
it has been closed with effect from January this year, 2023.
so your
Are you stating that fact in your affidavit?
That too, I have not stated that,
Then,
Lordship.
then.
Lordship, if that is
That
the
means
case,
it is continuing, it is going on.
Lordship, then in that case, to come up after 2 weeks.
After
as
2
per by-
weeks.
As per by
Yes.
the petitioner,
Okay, then
Lordship.
after 2 weeks. Then it is submitted that the state has filed their affidavit. Is it available with the case record?
The compliance, the
see.
distribution in Lordship.
Item number 7. Oh, is file, na? Is file or not? Is it file or not? One, two, three, state, na? State, na? Okay. Has filed your affidavit. Then after 2 weeks, madam, after 2 weeks,
Lordship.
Your Lordships, I also beg to mention item number 6, if it can be listed after 2 weeks for hearing. Item number
after 2
6.
weeks, on request of learned counsel appearing for the petitioner list after 2 weeks.
Lordship, I'm appearing for respondent number 3. 6. Your Lordship, another item number 11, if this can be fixed, if it can come up after 3 weeks. Item number 11, PIL 1 of 2021.
You have almost covered half of the list. Seeking it. All right. After 2 weeks,
3 weeks, my lord.
after 3 weeks.
Much obliged.
Yeah, please, Your Lordship. I beg to mention item number 8, PIL 21 of 2020.
Item number 8.
Lordship, I pray that I may be given 3 weeks' time to file my compliance, Lordship. I'm for respondent number 2 and 3.
2, 3, and 4.
2, 3, and 4, Lordship.
Learned counsel appearing for the respondents number 2, 3, and 4 has sought for time to file a affidavit. Affidavit?
Affidavit in compliance, Lordship.
Answer. Madam,
I'm for the petitioner, Lordship.
you are for the petitioner.
Yes, Your Lordship.
Your name, please?
Nitya Koza.
Nityo Koza.
Yes, Your Lordship.
Okay. After 2 weeks,
3 weeks, Lordship.
3 weeks.
Lordship. Lordship, similar prayer for item number 9 also. PIL 23 of 2020, Lordship.
Okay. After 3 weeks,
Lordship.
same order.
9 and 10, Lordship, is
9
analogous.
and 10.
Lordship.
Yes.
3 weeks. Obliged, Lordship.
Lordship, I beg to mention item number 15, 1-5, Lordship.
1-5.
Yes. Lordship, in the last occasion, I was given direction to file an affidavit as regard to the setting up of blood component separator in Eastern Nagaland, Lordship. Now, Lordship, as per instruction, to set up a blood component separator, the district hospital should have a registered blood bank. Now, recently, I've got information that work order has been issued in Eastern Nagaland side, Lordship, for construction of blood bank. Only after having a blood bank, then the blood component separator is given, Lordship. So the blood bank, for setting up blood bank in Mon, Kifri, Tingsang, and Peck district, work order has been recently issued. I was informed in the month of December. So, Lordship, I may be given 3 weeks' time to file an affidavit in compliance with the last order.
Already work order has been issued.
Yes, already issued, Lordship, to set up blood bank. Because the prayer of the petitioner is to have a blood component separator. Only after blood bank is there, Lordship, the blood component separator will come, as per the guideline of the ministry. So, Lordship, I will be given 3 weeks' time to file an affidavit to that effect.
No
in compliance
objection,
with the
Lordship.
In 3 weeks. Okay, 3 weeks.
Lordship.
Have you filed affidavit?
No, Lordship.
Not filed.
No, not yet filed. I'll file
In the
my-
meantime, you will file affidavit?
Yes, Lordship.
That's it. Sought for 3 weeks' time to file the affidavit.
I'm for respondent number 4.
As work order has been issued for installation of blood bank.
Lordship.
Where?
In Mon, Kifri,
Mon,
Kifri. Lordship,
Kifri.
I'm not very sure, but Mon
Okay.
in Eastern,
Okay,
in
okay.
Eastern Nagaland, Lordship.
At the places involved in the instant
PIL.
petition.
Lordship.
Yeah. Okay. You were representing
Respondent number 4. And Mozoi. 1 to 4.
and was 1 to 4,
Lordship.
3 weeks.
Lordship.
Lordship.
Oblige, Your Lordship.
Lordship, I also beg to mention item number 4. Lordship, I have not received any instruction as of, I am for the Union of India. I have not received any instruction that I pray that 4 weeks' time may be granted to me.
Did you take adjournments earlier too for this?
No, on the last occasion, on the last date, the Union were directed to seek instruction. But so far, I have not received any instruction.
Mr. So-and-so, your CGC, no?
CGC.
Yeah. Done at CGC. Appearing for respondents number. Respondents number. Okay, CGC.
8.
8 only.
Resolution.
Younger at Wati. 3 weeks time.
Lordship, at least 4 weeks.
4 weeks time is required to obtain the required instructions, so as to enable him to file the affidavit in opposition. The petitioner's side has no objection. Okay. Released after 4 weeks.
Much pleasure.
Oblige, Your Lordship.
For motion, item number 1.
Please, Your Lordships. Lordship, in compliance with order dated 14/09/2022, this IA was filed praying for impletement of the contractor in this instant PIL, Lordship. Now, Lordship, this PIL concerns the construction of Tening to Lekki Road, which is interstate road of Assam and Nagaland. Now, one of the prayer of the petitioner has been answered. That is, the execution of work is commencing, Lordship. But it is also the humble prayer of the petitioner that in order that justice is done while constructing this road, Lordship, in order that the road is done, completed on time, Lordship, this IA is filed to implement the contractor so that to monitor the work progress, as this honorable court has also done in other PILs, Lordship. Lordship, so my prayer is to implement MS Nagami Infratech Private Limited as respondent number 5,
No,
Lordship.
you have filed one IA for
Yes,
that
Lordship.
purpose.
Lordship.
That I've seen that prayer has been allowed. You will ask to implement the contractor.
Lordship, yes. Last
But
time,
he is yet to be implemented.
Lordship, yes. So I filed this IA praying for
All
to
right.
allow the implement, Lordship.
Yes, the already order is there.
Lordship,
Then
Lordship. In that case,
your IA has already been allowed.
Lordship,
Okay, you are seeking time or what?
Lordship, I was a little confused because when this matter came up for hearing last time, I was instructed to serve a copy to the central government's council, Lordship. So accordingly, I did it.
See, if he is a necessary party, he should be implemented.
Lordship, yes, Lordship. Yes.
Then why you implement him?
Lordship.
Copy not required to be served, I think. As you have already filed the IA, of course you can supply a copy to the other side. But he is a necessary party here
Yes, Your
because
Lordship.
he is responsible for implementation of that project.
Lordship. Yes, Lordship.
On the Assam side, it is zero.
Yes.
On the
Yes, Your Lordship.
Nagaland side, it is to some extent few kilometers. Who is appearing for the other state? Who is appearing?
For the state, Lordship. Yes.
You are representing.
Yes, yes, yes.
Let me see that. Have you furnished copy to the CGSC as per order dated 14/12?
Yes, I did, Lordship.
You
I
did.
did, Lordship.
I have received.
Is there any objection? No objection, I think.
No.
Hearts. Give the names. By this interlocutory application, the petitioner, the applicant has paid for implement of contractor uh, in respect of where is the work? Uh,
Lordship,
where it is mentioned?
yes, the name of the road is
But it
tending
is-
to Lekki Road, Lordship.
Let's see. Name of the work?
Name of the work project is tending to Lekki Road.
Okay.
Lordship, it's the project is mentioned in page number 26, Lordship. I haven't closed it.
26.
Yes, Lordship, of my main petition.
26. Yes, turning to Lekki.
Yes, Lordship.
Lekki route within bracket 37.5 km. Bracket closes in Nagaland. In compliance, continue. In compliance of the order dated 14/9/2022 passed by this court, where in PL number 3, in a connected PL number 2 of 2021.
Lordship, yes.
Okay. Upon hearing of both sides, it is found that the contractor of the project is a necessary party and as such its improvement is necessary. In view of above, registry to imprint the name of the contractor. Please give the particulars of that contractor. I think not given. The contractor name is the Messrs. Angami Infratech Private Limited.
MS Nagami Infratech.
As respondent number 5. 40. The petitioner shall thereafter take steps for service of notice.
Lordship. Oblige, your Lordship.
I stand disposed of.
For motion, item number 2.
May I please, my lord? Yes, I'll be filing objection in IA 205, your lordship. That is false.
You will file objection.
Yes, I have no objection in 204.
You have no objection.
Yes, yes.
Okay.
But I'll be filing objection in 205, your lordship.
By this interlocutory heard also. By this interlocutory application, the petitioner of the state of Nagaland has prayed for condonation of delay of 202 days
Yes, Your Lordship.
in preferring the instant writ appeal against
Page 2, Your Lordship. Page 2 in my IA. Page 2.
yes,
Judgment
against
and
what
order.
you want to prefer.
Yes, judgment and order dated 11/4/2022.
Judgment and order dated
11/4/2022.
11/4/2022 passed in.
But passing a WPC number 21 of 2021.
Okay.
Yes.
Paragraph numbers 3.1 and 2, 3.1, 2, 3, 4, 5. Having considered the above stated grounds and also the issues involved in the appeal, connected appeal, this court finds it expedient to condone the delay of 202 days in filing the instant writ appeal. Accordingly, I stand disposed of. The registry has already registered the appeal
Yes, Your
without
Lordship.
condoning, waiting for condonation of delay. All right. Okay. Registry to list the connected writ appeal number 35 of 2022. Delay condone.
Much obliged.
You have no objection.
For admission, item number 14.
May I please, your lordships? Lordship, I beg to mention on behalf of Sir Mo Ancient Lordship. Lordship, I'm yet to file my affidavit, so kindly permit some time, Lordship.
Yet to file.
Lordship,
Have you received the required instructions, etc., from the concerned department?
Lordship,
Or you are waiting for instructions, I think.
Lordship, I have no instruction from my colleague, Lordship. I'm appearing on behalf of.
So and so learned government advocate appearing on behalf of whom?
Mo Ancient.
Submits that as the learned senior is not available today, she has no instruction whether the affidavit in opposition has been prepared or not. and it just seeks some time to get the necessary clarification. Yeah,
I'm for the petition, Your Lordship.
MS so-and-so, appearing for the petitioners, has no objection. Release after 3 weeks. After 3 weeks?
Lordship. Obliged, Lorships.
For admission, item number 16 to 18.
Yes.
Very gracious, Your Lordships. The present rate is a challenge of the service rules, Your Lordship. Nagaland Employment and Craftsman Training Service and Nagaland Subordinate Employment and Craftsman Training Services Rules 1998, Your Lordship. So, before going to the background facts, Your Lordship, I would like to take Your Lordship to the
Who is appearing for the respondent side? Yeah,
My lord, I am for private respondents.
answer, private respondents. Okay. Yes.
Annexure E, page 63 is the imbued
Page 60.
service rules, Your Lordship. Page 63.
Yes.
Your Lordship,
63.
I'll take Your Lordship to the section 3, which is page 66.
Section 3.
Section 3, page 66, Your Lordship. Constitution of Service, Your Lordship. Section 3, Rule 3, Your Lordship. If I may read. The service shall consist of the following wings headed by director, and under the wing of the following categories of posts shall be considered. So director, class 1, selection grade, then A is employment wing, B is craftsman training wing. The present petitioners belong to the craftsman training wing, Your Lordship. So the equivalent posts of the two services have been clearly laid down, Your Lordship. So number 1 under the Roman 1 is Nagaland Employment Service Class 1, that is A, Senior Grade 1, Joint Director. So under Nagaland Craftsman Training Services Class 1, Senior Grade 1 is Joint Director is given. B is Senior Grade 2, Deputy Director, Regional Employment Officer. So under this category falls Deputy Director and Regional Employment Officer under the employment wing, whereas under the craftsman, it is Deputy Director, Principal, Senior Grade. Then C is Junior Grade, Assistant Director, District Employment Officer. So Assistant Directors and District Employment Officers belong to the same grade. C under the craftsman training wing is Junior Grade, Assistant Director, Principal. And so the services
These are the equivalent posts.
Yes, these are the equivalent posts. And the classification is clearly laid down under the Rule 3. Now, Rule 5, Rule 4 talks about strength of service, and Rule 5 method of recruitment, where it points to the schedules that the promotion and appointment shall be in accordance with the schedule.
Yes.
Your Lordship. So I am aggrieved with the distribution of posts and the manner in which promotion is granted with regard to the higher services of joint director and director only for the employment wing. This has been laid down under the schedules, Your Lordship. I'll take Your Lordship to the imbued schedule. The Schedule 1A, Your Lordship, is at page 75. Schedule 1A. Here, this is with regard to the Schedule 1A and 1P, Your Lordship. These are the distribution of the posts for the two wings, Your Lordship. The Schedule 1A is for Nagaland Employment Services Class 1. Director, Schedule 1A, the first A, selection grade is director, so it falls for both Nagaland Employment and Craftsman Training Services Class 1. The grade pay is specified. Then under the head Nagaland Employment Services Class 1, B, senior grade, joint director, one post is indicated. Temporary and total is one post. Senior grade 2, deputy director, class 1, it is one post. Number of permanent posts is 1. Temporary posts 2. Altogether 3. 3 posts. Regional employment officer. So this regional employment officer is also a deputy director, Your Lordship. They are equivalent rank. So one post of employment officer. So altogether there are 4 posts of senior grade 2, that is including the regional employment officer. So for the employment services, there are 4 deputy director posts, Your Lordship. Then assistant director, 2 posts, and total is 2. So now the number of posts assigned to the employment services is, as I have indicated, as I have taken Your Lordship to the rules. Now, Schedule 1P, the next page. Here, this is with regard to the Nagaland Craftsman Training Service Rules, Class 1. So here, under this, senior grade 2, no posts of joint director, Your Lordship. Only deputy director is indicated. 1 post. So there is a difference of the employment services has three deputy posts of deputy director more than the craftsman training. Principal, this is with regard to senior grade, there is 1 post indicated. So altogether there should be 2. But as I have made specific statement in the petition, to which I will take Your Lordship to, only 1 post has been assigned. That the post of principal senior grade has never been granted to any of the officers under this grade. Now, then under the junior grade principal, 1 permanent, 1 temporary, and there are 2 total posts. And then the vice principals, they fall under class 2G. So these are the numbers that have been assigned, Your Lordship. 1 temporary, 1 permanent, and so there are 2 posts. But what I am aggrieved with is with regard to the post of joint director. No joint director posts in respect of the craftsman training has been laid down under the schedule, number 1. Number 2, with regard to deputy director, the discrepancy in the number of posts that has been granted. So I am aggrieved by this unequal distribution of posts, Your Lordship. Now, I'll take Your Lordship to Schedule 2A, the next page. Employment, this is with regard to...
Where you are presently posted?
Your Lordship, we are... one is at the directorate, the others as
To
principals. and
which
vice
category
principals.
you are belong?
We belong to the
Craftsman
Craftsman Training Wing, yes. We are the first petitioner. The petitioner number 1 initially was holding the post of joint director.
What's the principle for
Now-
creation of post? What's the principle for creation of post by the government? What is the
Lordship-
principle followed?
Your Lordship, it is up to the...
There must be need, no?
Yes,
It must be need based.
Your Lordship, yes. So I'll take Your Lordship to the factual position earlier and how it came about in this manner. But I am taking Your Lordship through with what I have agreed with initially, before I take Your Lordship to the other facts, the background facts, Your Lordship.
And other side, respondents' side? No problem.
My lord, I represent for the private respondents.
That's it.
The principal, lordship has posed a pertinent question. The principle to be taken into consideration for creation of posts is as per the guideline, based on the seating capacity of the trainees for them. ITI means to give vocational training for the skilled laborers, like workshop, to run a workshop for the weaving, knitting, instructor, for sewing. All this needs vocational training. And the functions and responsibility of the ITIs. Training wing is to teach, not for administrative function. So for them, in order to create posts above principal, the very nomenclature called principal means to teach in institute. There, for them, basically to teach the trainees, vocational trainees.
Actually, skill development.
Now, skilled laborers. Now, since this employment as well as ITA falls under concurrent list 3, concurrent list in the Constitution of India. Government of India always lay down the models, the guidelines, what the seating capacity, how much should be there for a particular post to be created as deputy director, joint director, how much seating capacity should be there. These are certain guidelines that I have. So therefore, in Nagaland today, I'm just giving the sketch. Nagaland today, as on today, there are only 639 trainees. Only 639 trainees for 16 districts. So when 639 trainees are divided by 16 districts, only 39 trainees for the respective districts. Then where is the question of creating posts for deputy director, joint director, additional director for ITIs? That is the consideration. Now guideline says the central government, because both employment as well as ITA falls under concurrent list, as I say, is under list 3. Government guideline is always followed. And in order to create posts for the post of joint director, there has to be 7,000 sitting trainees, sitting capacity for trainees for the post joint director. I'm just giving rough now. Then for the post of deputy director, the trainee sitting capacity required 4,000 as per a guideline. in Nagaland, all over the state, only 600. So where is the question of discrimination that post was not created for the ITIs? That is the stand of the government, and I have factual figures. I have enclosed the sitting district-wise house that has distributed how much trainees are there as on today. So therefore, now coming to employment, the very purpose of establishing the Directorate of Employment for administration, our responsibilities, our duties, our function is for administrative work. We should become director, join that for administrative purpose. In 1986, Lordship knows very well with your experience. All over India, there is no particular directorate for ITS till today. They are attached with a particular department under a particular directorate all over the world, all over India. I have the figures. Now, since they are meant for teaching the vocational trainees, for skilled laborers, until and unless there is vacancy, unless then the demand to create vacancy for joint director, additional director, where is the question of creation of posts and promote them? Show them. Let them show that in Nagaland, we have more than 3,000 trainees. So one post of deputy director is required. Let them show. Let them show that in Nagaland, there is more than 7,000 trainees. So at least joint director post, let them show. If it is not there, where is the question of discrimination? In the case like this, my lord knows very well about this case. Petitioners are rightly or wrongly challenging the rules, question of interpretations of constitutional law. They are saying violating of 14 and 16 of the Constitution of India. Where is it? In order to challenge the rules, it will be only on two grounds. One is if the rules is constitutionally invalid. Only on two grounds I can challenge the rules, statutory law. If the rule is constitutionally invalid, let them prove that it is constitutionally invalid. One. Ground two will be if the rule is ultra vires or excessive delegation of power. When the rule was framed by an incompetent authority, then challenge comes. And Lordship knows very well in this case. Where is the question of invalidity of constitutional norms? Which constitutional provision has been violated? And
Mr. Ezo,
my lord.
The service rules.
Yes.
Rule 3
Yes, my lord.
says that constitution of service.
Yes.
The service shall consist of the following wings headed by the director, and under the wing of the following categories of posts shall be consisted.
Yes.
So what I understand,
Yes, ma'am.
correct me if I'm wrong,
Correct, sir. Yes.
for promotion to the post of director,
Yes.
the senior-most joint director from either of the wings
Yes, madam.
shall be considered. Is that right?
No, madam. No. This is only
Then you please explain rule 3.
My
Please
lord.
explain rule 3.
Correct. Rule 3 is the provision where it is provided for future promotion. It'll depend on the seating capacity only. It is not that there should be all these posts. They should be, because this has been clarified in the schedule, my lord. Schedule 1, schedule B, my lord.
No, that's why. When actually in rule 3, in the
Madam.
constitution of service,
Yes, madam.
the craftsman wing, the training wing,
Yes.
also has scope for promotion to joint director.
Provided.
Just listen. Joint director. Why this joint director post is missing in schedule 1B?
That's what I'm saying.
I think you will have to clarify that.
Lordship is correct. Why? Why it is missing? Because there is no seating capacity today. When there is no requirement, when there is no need for creation of post, how can the government be compelled to create post when there is no necessity to create post?
Then what was
This
the
is-
necessity?
My lord.
What was the necessity of actually like including joint director in the craftsman training wing in the Constitution of Service.
Under Rule 3, my lord. Yes, my
What was the necessity?
My lord.
If we go by your argument.
My lord, my lord.
What is the necessity?
My lord, the
To
necessity
actually
is,
have this post in this wing under Rule 3.
necessity is, as per central guideline for ITIs, if number of seating capacity increases, then obviously they'll have joint director also. Obviously they'll have additional director also, provided there is seating capacity, my lord. Provided there is increase of trainees occupying seating capacities, my lord. There are a lot of guidelines by central also. So therefore, Lordship will see. My lord, Schedule 2A. That will clarify the Rule 3, my lord. Schedule 3A. May I read it, my lord?
All right, Learned Council, Monday is for admission hearing. It will require a detailed hearing.
It will take some time.
That, Learned Council, do you want to say anything? Government side? Government side, anything? Your party here, no? Then
It will take a long time, man. We want to finish it. Once we start, we want to finish it, my lord.
this is a new matter. Hard give the names. Issue rule list for hearing. Do you want a fixed date?
Yes, a fixed date.
Fixed date.
Yes, my lord.
Any date? On 15/3 for hearing.
My lord. My lord. No problem, my lord. Much obliged.
For admission, item number 21.
Your lordship, the interim may continue.
Oh, interim order is there?
Yes, your lordship.
Okay. Interim order passed earlier will continue.
Much obliged.
Ecclesial Lordships. My Lord, as per the direction of this Honorable Court, we have published the notice in our local daily, circulated within the state of Nagaland, as well as one national newspaper, that is the Times of India. So, my Lord, the notice may be deemed complete. The next date may be fixed for appearance, Lordship.
Have you filed a affidavit?
Yes, my Lord, we have filed our affidavit. It was filed on 21st
As per
of
order dated
February.
18/1, na?
Yes, my Lord.
18/1. Order dated 18/1.
Lordship,
Mr.
Joshua,
Joshua Cheki,
my Lord.
Learning Council appearing for the petitioners. And respondent side,
State respondent, I had already filed my affidavit.
you have filed.
Yes.
My Lord.
Give the name. Government affidavit. It is filed. As per order dated 18/1/2023, steps has been taken for publishing in where?
National
Publishing
newspaper.
notice in a national newspapers and to place as all it. Where published?
My Lord,
In which issue?
show me the newspaper.
Where is the affidavit?
My Lord, the affidavit was filed on 21st of February 2023.
Let's see. This one, I think.
It was published on 18/2.
Accordingly, notice has been published. In Times of India, in its issue dated
18/2/2023, Lordship.
18 to 2023. Were they? Were the respondents?
My Lord, not all the respondents are from Nagaland. That is why the direction was also to publish in one national daily, Lordship. My Lord can see the list of names at which page number?
Starts from serial number 5, you see. Where? So what? You have the right to receive a notice. If they miss the issue, if this newspaper are not circulated in the area. Did you issue notice by registered ready post before publishing the
Yes, Lordship.
newspaper?
We have done that.
You have done.
We did that, but Lordship, the problem is we do not know the address of this respondents. In fact, we did not even make them a party in the first place because the exam was yet to be conducted. But it was by the direction of this Honorable Court that the applicants, they have to be impleted. If not, respectfully, Lordship, I did not find the necessity to implead them because the exam was yet to be conducted.
You could have obtained their addresses through RTI.
No, Lordship, we did that. But even the office said they do not have their addresses. I do not know how they have been able to contact them.
But simply Ratan Kumar, roll number 849, like this, serial number 39, say,
Lordship.
without any address, how it can be treated as sufficient service?
Lordship, it is by the direction of this Honorable Court. If not, the office themselves, in the RTI reply, they do not have their own
See,
their addresses.
Question of justice. Notice means knowledge.
Lordship.
It is your duty to bring to the knowledge of these candidates. So, ought to have, this registered report ought to have been issued to them, but only by publishing in the newspaper. Do you think that it is sufficient service?
Now, my Lord, may I kindly appreciate this fact. The petitioners are all unemployed. In fact, even to publish this, they have to sacrifice a lot of resources to be able to publish this. Now we went to the office since this Honorable Court had given a direction that they have to be impleted. We asked for their addresses. We did everything that is, Lordship, under the book. We have tried, Lordship. But even the office, they said they will come by themselves, and they have not been able to provide us the detailed addresses.
All right, this publication also shows that you have not given given the context. In what context they are summoned? They are served with notice. WPTC number 123 of 2023, Sri Thangminal Thamsang and 21 others. In what regard?
My Lord, may I kindly appreciate in the advertisement, the lower portion, Lordship.
Yes, I have seen.
Lordship.
Is it sufficient? You see, what grievance is there to it?
Oh, my Lord,
Problem
this,
is there now.
yes, Lordship. But this is the normal.
Definitely, I
yes.
don't think that they will contest your petition, but at least service of notice is required now. Proper service of notice. What to do?
No, Lordship, they
All
have
right,
not.
this is
Yes,
also
Lordship.
accepted,
My lord.
but it is not deemed served. Then you take stays by registered ready post too. You have to bear with it. No? It is a legal requirement. It cannot be vague.
No, Lordship.
Hmm?
When the office themselves, where the respondents or one of the petitioners applying in a job, when the office themselves are not being able to provide the address to us, Lordship, it will become an unnecessary punishment upon the petitioners when respectfully it was not even necessary to implead them. They have not been selected. But out of the respect for the direction of this Honorable Court,
They are not they are not selected.
they have not been selected as
Then
yet,
why
Lordship.
you have implemented them?
Lordship, that is why. That is why, Lordship.
All right then.
They have not been selected, so I requested this Honorable Court, Lordship.
Unsuccessful candidates are implemented. Yes, sir. The notice was duly published in the Times of India in its issue since we already stated. Okay. Notice is deemed served on the respondents. Number
5 to 76, Lordship.
5 to 76.
My Lord.
Who are 1 to 4?
My Lord, those are the state respondents.
Lordship, I'm for the state.
No, you are for a state, but names are not here, no?
My Lord, the
1 to 4.
Lordship.
1 to 4 not available.
No, 1 to 4 are the state respondents, Lordship. The state of Nagaland represented by the Chief Secretary, Government of Nagaland. Respondent number 2 is the Commissioner and Secretary to the Government of Nagaland, Department of PNR.
Where is that? Here starts from 5, no?
And, in my read petition, Lordship, we'll find it at page number 10, the state respondents, 1 to 4.
Oh. And last page. 1 to 4. Their names are in page number 10,
Yes, Lordship.
which is not tagged in the initial pages. This is the last page. All right. So the notice is deemed served on the respondents number 5 to
76, Lordship.
76. Madam, affidavit is filed, no?
Yes, I had filed
Okay.
it, Lordship.
Give some time. As notice has already been published,
My Lord.
they may also contest their petition.
Lordship.
Give them some time.
Lordship.
Okay. The list after none appears on behalf of the respondent number 5 to 75.
76, Lordship.
76. List after 3 weeks.
My Lord. Lordship.
That's okay.
Oblige your Lordships.
For hearing, item number 23.
May I please, Your Lordship? May I please, Your Lordship? Lordship, this is a very short matter. And before I take Your Lordship to the order against which this appeal is preferred, Your Lordship, just facts in brief. Now, the opposite party petitioner, he was initially appointed as work charge laborer on temporary basis, and subsequently was upgraded to work charge semi-labor, semi-skilled labor. Under the establishment of SDO, Sub-Divisional Officer, PHE, PEG, Your Lordship. Now, thereafter, he was promoted to the post of Chogida. He was given a skill pay. And while serving as Chogida, Your Lordship, the opposite party, the petitioner, he was released from service with effect from 31/1/2014. Now, but he was released without any pensioner benefit. And therefore, the opposite party or the petitioner, he has approached this Honorable Court by way of filing writ petition number 215K of 2021, praying for regularization of his service and for grant of pensioner benefit, Your Lordship.
Where is the release order? Let me see.
Release order, Your Lordship. The
Page number.
release order from pensioner.
Has a relation with this. If that is from other states also. No, from like,
No, Your Lordship, in the writ.
Yes, Learned Counsel.
In the
Is
writ.
there any similar matter pending in the apex court? You remember?
Even last night, Your Lordship, I have asked the standing counsel. She informed me that till now there is no review been filed before the apex court.
It is yet, it is not reviewed till now.
No application has been filed. Nothing regarding with this.
That is pertaining to.
Please wait.
Posthumous
So, in that case, the Supreme Court did not give any review for retrospective regularization and service for pensionary benefits. So, I think after that, the petitioners are again sought for a review, but now as per the petitioner. No review has been done. That is what it is. So,
Page 35. Page 35.
He was the former senior.
Yes.
Yes. Because you are familiar.
Mr. TB,
Lordship.
whether actually the case which was disposed by the Supreme Court on retrospective regularization.
Yes, retrospective.
Yes. Whether that has a similarity with the present writ.
Lordship,
To my knowledge, Your Lordship,
that is pertaining to a person who was serving and he expired. So a petition was filed in this court asking for pensioner benefits. The London single bench allowed, division bench allowed, but apex court has interfered. That posthumous regularization is not.
Posthumous, retrospective, I think these are all more or less same. Posthumous or retrospective. Because posthumous is also giving retrospective effect.
Yes.
For
And Lordship,
regularization in service for pensionary benefits.
recently also this. honorable
So
court-
that is why Lordship wants to know whether actually the facts which was disposed by the Supreme Court is also similar with the present case.
Because in that apex court, Lordship, if I remember correctly, Lordship, that is pertaining to posthumous specifically.
No, but posthumous regularization
Lordship, I have a copy of, I have only one copy, Your Lordship, of the
Yes.
judgment passed by the Honorable Supreme Court. In that case, Your Lordship, the matter relates to posthumous regularization, and the Honorable Supreme Court has held that when the deceased was not entitled to be regularized during his lifetime, how can he be regularized after his
So that is why there's a clarification from us. Posthumous, retrospective.
retrospective?
The end result is same.
Yes.
Yeah,
During his service time, when he was not entitled to regularization, how can he be regularized after his being released from service? That principle, Your Lordship, in a way. That's all. Oh, yes, Lordship, that is under the copy. It is NISCV. Relevant para will be para 8, Your Lordship. Para 7, may I read out? Having heard learned counsel for the state and considering the submission made on behalf of the state and having gone through the judgment and order passed by the learned single judge confirmed by the division bench, we have the firm opinion that the High Court has committed a grave error in directing the appellant to regularize the service of the deceased employees 1 day prior to his death. In this case, it will be 1 day prior to his release from service.
Yes.
Yes. It is required to be noted that the deceased employee died in the year such and such. During his lifetime, he never claimed for any regularization. In fact, this also is the case. When he was in service, he never claimed for regularization. So in a way, Your Lordship.
Let them come properly instructed, let them come with proper instruction as to whether this order will cover this. Because on earlier occasion on main reference, I have actually asked the learned counsel to kindly clarify whether the Supreme Court judgment would also cover those cases.
This judgment also covers this case, facts of this case. Same thing.
It was put to person said.
Yes, where is the release order?
Release order, Your Lordship, page 35. Page 35, this release order is annexure D to the writ petition filed by the opposite party, Your Lordship. Lordship has got it?
35.
35.
Hereby release.
Such-
the income
understand is
from,
hereby release.
After obtaining the age of superannuation.
Of 60 years.
What superannuation is there?
But he was not granted any pensioner benefit. Therefore, the opposite party petitioner has approached this honorable court by way of filing the writ petition, Your Lordship, 215 of 2021, praying for regularization.
Learned counsel, whether the facts of this judgment, they also cover the facts of this petition.
Facts, Your Lordship, of course, facts will differ in every case, but the ratio, what is the principle laid down, that is the thing. And in fact, Your Lordship, the petitioner, opposite party petitioner has taken 3 grounds for claiming the relief, Your Lordship. Now, for a moment, may I take Your Lordship to the grounds, Your Lordship?
So I think all this should be kept together. Similar. Yes, we don't got any confusion. And single bench also, I think there are some single bench.
Similarly situated.
Similarly situated. Posthumous retrospective regulation.
We could have, if we dispose of this one. So
There's also
other
petitions. But again, I think there are actually similar matters coming before the division bench also. So all this can be cleared.
Yes, the learned counsel.
Lordship.
There are similar matters pending in this bench.
Yes, Ms. Sokre,
Similar.
you
What
can
should we
assist this court.
can we club together?
Lordship,
Lordship,
yours is, I think the facts of the case are different.
May be different, but the relief sought for may be similar.
Retrospective posthumous.
Huh.
There are, I think, some other petitions.
All petitions can be disposed of
I-
together.
If that is the case, it will be better if all the
All the
petitions are
cases-
clubbed together, Your Lordship.
so that the court does not pass any conflicting judgment.
Lordship, because, Lordship, if I may be allowed, recent judgment of this honorable court, as far as regularization is concerned.
All right, you will be heard, but let all the matters, similarly situated matter, involving the same questions of law,
Because there
may be heard together.
facts may differ, Lordship.
Facts may differ.
Facts may differ,
Because
but only
The
on
relief,
posthumous and retrospective.
the relief.
I think, as we have said, the end result is the same.
Lordship, in my case, the petitioner, since they do not come within the policy of the government for regularization, they are banking on the Central Civil Service pension rules. Yes. So that will be
same
it's
here.
like yes, but
So more or less same. So
Same.
as Lordship has said, if all the cases, similar cases can be clubbed together,
Yep.
so that I think any judgment passed.
Then if additional AG can give the list of cases so that all the cases can be listed together, that will be
Yes.
better.
Next week.
After fix it. It will take clubbing means those cases have to be identified. Then those concluded. Some scrutiny will be there is the research in
one disposal is people because of the other case.
No, I think it is only the registered bench. Joint registered bench.
So it will take
after 4 weeks.
And the regime should
Okay, heart. Learning Council for both the says. In course of hearing of the matter, it has come to light that several other similarly situated petitions are also pending with events. Therefore, we find it expedient in the interest of justice to club all the similarly situated writ petitions, writ appeals involving the same questions of law for delivery of common judgment, if that can be conveniently be done. So, Learned Additional Advocate General is requested to furnish a list of such cases petitions pending with this court, and also the register bench, no? Who is here?
Who? Joint register.
Joint register bench.
Who is the judge? Joint register.
Joint register judicial shall identify those cases and club the same and list accordingly after 4 weeks or a fixed date. Fixed date will be convenient, I think. Both sides will be able to get ready.
Lordship.
Hmm?
Lordship. As per convenience.
After 4 weeks,
Any date.
it will take time.
Any date, your Lordship, as per convenience.
After 4 weeks means on 29 March.
On 29th of March. Any inconvenience?
No.
Although the next item also.
Same.
Yes. We will.
Next item.
Because,
Yes.
Lordship, in my opinion,
Item
Lordship,
24.
there will be a lot of difference in the facts as with regard to the even question of law.
That's why I have mentioned involving the same questions of law.
Oblige.
Yeah, on 29.
For hearing item number 24.
Lordship, here is also with regard to the regular.
Same.
Yes.
Yes.
So that I'll
Same.
provide the. Yes.
Much obliged.
For hearing item number 25.
May it please your lordships. In fact, my lord, this is actually a covered case. A similar case was before the Honorable Supreme Court, where an advertisement was issued, the appointment process was completed, but in the process, after the initial advertisement, there was some change of condition. Now, changing the rule after the game is started, lordship. The Honorable Supreme Court, in a similar case in Arunachal Pradesh, has issued a direction to the state respondents not to change the game after the game has started.
Not to change the rules.
Not to change the rules after the game has started, lordship. Thank you, lordship.
All right, I've taken it correctly.
My lord, even
What's the
without
number of that case, which is presently pending before the Supreme Court of India?
not pending, lordship, it was
It
disposed of by the
disposed of.
Honorable Supreme Court. Where's the judgment list?
They are catching up decisions on this.
Yes, lordship, lordship. Now, my lord, 2008 3 SCC 724, paragraphs 11 and 12, this is Madan Mohan Sharma and another versus the state of Rajasthan and others. Lordship, here also, once the advertisement has been issued on the basis of circular obtaining at that particular time, the effect would be that a selection process should continue on the basis of criteria which were laid down, and it cannot be on the basis of the criteria which has been made subsequently. Here in this case also, lordship, the graduate teachers. Now, my lord, advertisement was issued. After the advertisement was issued in the old pay scale, lordship. Once the result was declared and the appointment order was issued, only then their pay grade has been reduced, lordship. Lordship, at paragraph 12, again it says that a subsequent amendment of the rules which was prospective cannot be made retrospective, so as to make the selection on the basis of the rules which were subsequently amended. And the case squarely covers this case, lordship. In 2005, 4 SCC, page 154, paragraphs 14, 15, and 17 also, lordship.
Whether in the advertisement the pay scale was provided.
Yes, lordship. The old pay scale was provided.
Page number?
Lordship, the first judgment that I'm relying upon is the 2008 3 SCC 724.
2008,
3 SCC, lordship.
3 SCC.
Page 724, paragraphs 11 and 12. If I may be allowed to read your lordships.
11 and 12.
11 and 12, lordship. We have heard learned counsel for the parties and perused the records. Mr. M.R. Kala, learned counsel, senior counsel for appearing for the appellants, has strenuously urged that during the pendency of the selection process, the eligibility criteria were changed and the date for submission of the application in pursuance to the advertisement was extended, and Rules 266 of the Rules of 1996 came into being on 30/12/1996, whereby it was provided that higher secondary examination shall be the criteria for preparing the merit list. As such, as per the service rules, the selection should have been made on the basis of higher secondary examination marks and not on the basis of secondary examination marks. We regret this cannot be accepted. Once the advertisement has been issued on the basis of the circular obtaining on at that particular time, the effects would be that a selection process should continue on the basis of the criteria which were laid down, and it cannot be on the basis of the criteria which has been made subsequently. As per the circular which was obtaining at the time when the advertisement was issued, dated 24/7/1995, the criteria for selection to the post of teacher grade 3 was secondary examination. Though this was changed during the pendency of the advertisement, subsequent amendment of the rules, which was prospective, cannot be made retrospective so as to make the selection on the basis of the rules which were subsequently amended. If this was to be done, then the only course open to recall was to recall the advertisement number 1 of 1996 and to issue fresh advertisement according to the rules which had come into force. Secondly, this was not done, and erroneously the authorities made the amended rules applicable and proceed with a selection which resulted into litigation, and ultimately Radhishyam Sharma succeeded in that litigation, and it was held that the selection should be made as per the secondary examination marks, the criteria which was prevalent at the time when the advertisement was issued.
Yes.
Now, my lord, in this case also, no fresh advertisement was issued. It was on the basis of the old advertisement that the result was declared. And by the time the appointment order was issued, it is the stand of the state respondents that the new rule had come into force, on the basis of which the pay grade was reduced, lordship, which, as my lord has rightly pointed out, is changing the rules after the game is started, lordship.
Yes.
If I may take your lordship to other judgments also. And
2005.
2005, 4 SCC, page 154, paragraphs 14, 15, and 17, lordship. This is the Secretary, Andhra Pradesh Public Service Commission versus B. Swapna and others. May I read, lordship?
Yes.
I'll start from paragraph 14, lordship.
Yes.
The High Court has committed an error in holding that the amended rule was operative, as has been fairly conceded by learned counsel for respondent number 1, applicant. It was an amended rule which was applicable. Once a process of selection starts, the prescribed selection criteria cannot be changed. The logic behind the same is based on fair play. A person who did not apply because a certain criterion, example, minimum percentage of marks, can make a legitimate grievance in case the same is lowered, that he could have applied because he possessed the said percentage. Rules regarding qualification for appointment, if amended during continuance of the process of selection, do not affect the same. That is because every statute or statutory rule is prospective unless it is expressly or by necessary implication made to have retrospective effect. Unless there are words in the statute or in the rule showing the intention to affect existing rights, the rule must be held to be prospective. If the rule is expressed in a language which is fairly capable of either interpretation, it ought to be considered as prospective only. And the rules, amended rules, in this aspect is also completely silent, lordship. So it is prospective. Then paragraph 15, lordships. Another aspect which this court has highlighted is scope for relaxation of norms. Although the court must look with respect upon the performance of duties by experts in their respective fields, it cannot abdicate its functions of ushering in a society based on rule of law. Once it is most satisfactorily established that the selection committee did not have the power to relax essential qualification, the entire process of selection so far as the selected candidate is concerned gets vitiated. In P.K. Ramachandra Iyer versus Union of India, this court held that once it is established that there is no power to relax essential qualification, the entire process of selection of the candidate was in contravention of the established
Mr.
norms.
Joshua.
Yes, lordships.
Yes, your case is that actually there was an advertisement
Yes, lordship.
stipulating the conditions. of
Yes,
appointment,
lordship.
correct?
My lord. Yes, lordship.
And before the appointment was issued, the new rules came into being,
Yes, lordship.
correct?
My lord.
And as per the new rules,
Yes, lordship.
they have tinkered with the conditions.
Yes, lordship.
That is precisely your case.
Precisely that is the case,
Okay.
lordship.
Now, in all the cases which you are citing,
Yes, lordship.
such a situation did not arise. No new rules came into force during the pendency.
No, lordship. The judgments that I have referred, lordship.
This is only about changing the rules of the game after the game is over.
Not only that, lordship. Not
But
only that,
whether
lordship.
in this cases, new rules were also framed.
Yes, lordship.
New
So
rules.
2008 3 SCC.
2000, let's see the relevant para.
2008.
which I have first referred, Lordship.
Yes, let's see that.
Yes.
I have referred to the
11.
paragraph 11 and 12, Lordship. May I read again, Lordships?
In rules. More particularly paragraph number 12.
Yes, Lordship.
Please read, please read.
As per the circular which was obtaining at a time when the advertisement was issued dated 24/7/1995, the criteria for selection to the post of teacher grade 3 was secondary examination. Though this was changed during the pendency of the advertisement, subsequent amendment of the rules, which was prospective, cannot be made retrospective so as to make the selection on the basis of the rules which were subsequently amended.
Once more read it.
Further, Lordship.
Just
Subsequent amendment.
Yeah, subsequent amendment of the rules, which was prospective, cannot be made retrospective, so as to make the selection on the basis of the rules which were subsequently amended, Lordship. It squarely covers this case, Lordship.
if this was to be done, then the only recourse open was to recall the advertisement.
Yes,
So
and
this was
issue fresh
before-
advertisement.
So this was before the selection?
My lord?
This was before the selection, in this case?
No, Lordship. The exam
After-
was, so Lordship, that is why, Lordship, the observation made by the Honorable Apex Court is that if the new rule is to be applied, then that advertisement could have been recalled and fresh advertisement as per the new rule should have been issued. In this case also, Lordship, before the appointment order was issued, they could have recalled the examination process which was complete. They could have issued a fresh advertisement on the basis of the new rules. Such is not the case, Lordship. Appointment order was issued, but at the time the appointment order was issued, Lordship, the new rule was applied by...
Before issuing the appointment order.
Yes, the new rule came into force.
And
But that is...
therefore, the conditions in the appointment order was as per the new rules.
Yes, Lordship. But not as per the advertisement which was issued as per the old rule, Lordship. So this case, the 2008...
I think this
yes,
issue, I think we need to properly think over, because in some cases,
Lordship.
during the pendency of the appointment, the new rules came into being. And the Supreme Court has upheld that issuing the appointment order as per the new rules, there is no infirmity. I think I have come across such judgments. So that's why I was a little bit confused.
My lord.
Therefore, with the permission of Lordship, I was... Yes, I think, but I don't know. It's like this.
When an advertisement is issued based on the old rules, that cannot be sent before selection. That cannot be sent during the intervening period.
I think this is to do with amendment of the rules, correct?
Yes, Lordship.
Amendment of the rules. That's all. Not new rules coming into force, but amendment of the rules. So I was.
It change the conditions of service.
Yes, change, more particularly the case.
Yes.
So that is why.
This must.
Even in this case also, Lordship, the old rule was amended and the new rule came into being.
How?
And if my lords will kindly appreciate the 2008 3 SEC, the first judgment that I have referred, it squarely covers. And Lordship, there are further judgments also which says that if amended rules are not retrospective in nature, or such language is specifically pointed out in the rule itself, then Lordship, no rule can have a
but the-
retrospective effect.
Retrospectivity may not apply in your case because you were not appointed.
No, Lordship,
No vested or accrued rights that occurred to you.
I beg to defer, Your Lordship.
To say that the amended rules have taken away your right.
No, Lordship.
Before
No,
your appointment,
Yes, Lordship.
before your appointment,
Yeah, Lordship.
you had no right on the post, or you had no right to the post. And before your appointment to the post, the rules were amended. So amended rules had not taken away any of your rights.
No, Lordship. If my lords will kindly appreciate the judgment that I have already
Because
read.
when
Lordship.
you actually elaborately go through the words accrued and vested rights,
which
Yes,
has been
Lordship.
defined by the Supreme Court.
My lord.
It only means some rights which you have actually accrued, not which is expected.
Now, my lord, will kindly appreciate this. Even the Honorable Apex Court has specifically said, in order that the new rule would not have an effect, to do away with the conditions of the advertisement which was earlier issued as per the old rule, Lordship. The only available remedy with the state respondents could have been to recall that advertisement because that the appointment order was yet to be
I
issued.
am actually on the retrospectivity,
No,
Because
sir.
you are saying that retrospective, because by actually like enforcing the amended rules,
Lordship.
it is going to take away your rights.
Lordship.
What
No,
rights have been
I got your point, Lordship, because that appointment order was yet to be issued.
Yes, so no rights
However,
are there.
Lordship,
No rights had actually arisen in your favor.
Lordship. Now, assuming that I fully agree with your Lordship, with your Lordships, here the issue is the advertisement was issued as per the old rules. Now, was that advertisement recalled before the appointment order was issued? The issue is here. The same was not done, Lordship. Even the Honorable Apex Court, at the course of repetition, your Lordships, they could have recalled that advertisement.
Yes, Ms. Sokre, the burden lies on you.
Lordship, see, Your Lordship, earlier there is a Nagaland School Education Service Rule 2002. So by this new rule, this is the new rule, not an amended, Your Lordship, amended of some of the provision. This is the whole new rules, where the old rule has been repealed, Lordship.
Oh, repeal, that is
Yes.
worse again.
Yes, that has been repealed.
That is worse again.
Yes. So, Lordship say, before their appointment, Lordship, this new rule came into being. So if we are to take what the petitioner is praying, then under what rule we will give them appointment, Lordship? It has to be according to the existing statutory rules, Lordship. Because the old rule has been repealed. And that point of time, when this rule came into force, Your Lordship, the petitioner was not appointed.
Now, at the time of advertisement,
Yes.
which rule prevailed? Old rule?
2002.
That is the new rule.
Yes, and this is
No, that is the old rule,
2017
Lordship.
is the new rule, Lordship.
2002.
That's the old rule,
Old
2002.
rule. That was repealed
Advertisement
by
was issued
the
as per the old rule.
2017 rule, Lordship.
No, that's why
Yes.
what we are saying is which rule subsisted
Yes.
when the advertisement was made?
2002.
2002.
Yes. When advertisement was given, this 2002 was there. But this the draft of this was in the process, Your Lordship. Because advertisement is on, Lordship. Advertisement is on August 2000.
28 August 2017.
28 August 2017.
But the pay structure as per the advertisement, as per the appointment, was different. Pay structure.
It is only the pay structure, correct?
Yes, only the pay, yes, Lordship.
That is what they are saying. We should and therefore our pay structure should be on the basis of all rules.
Now, if my lords may kindly appreciate, there are graduate teachers in the state government, under the state of Nagaland. There are graduate teachers. One category is enjoying the grade metrics level 10, pay metrics level 10, and the other graduate teachers who are performing the same duty in the same rank. They are given a pay metrics level 9. In fact, I believe some will even
Lordship,
come and
it's
challenge
like
these
this.
rules. But
Lordship-
here before your lordships, the only issue is advertisement was issued where the pay matrix is the old pay matrix that is level 10. And at the time the appointment order was issued, the same has been changed, lordship, and reduced to level 9, lordship, against the advertisement.
Yes.
So, Your Lordship, there is nothing wrong, infirmity in the judgment of the single judge. Your Lordship say, if the petitioner, they are a graduate teacher, earlier by the old rule, there is no differentiate between the graduate or a senior. Only by the new rule, the graduate teacher has been differentiated into a senior graduate teacher and a graduate teacher, Your Lordship. So the pay which was mentioned in the advertisement pertains to the senior graduate teacher level, Your Lordship. So the petitioner
But
is,
have you mentioned that in the advertisement?
Lordship, in the advertisement, there is nothing, we have not mentioned. Because in the old rule, there is nothing as such. All graduate teachers are given same scale of pay, whether they are serving for many years or not, Lordship. Only by the new service rule, the graduate teacher has been broken into two class. Senior graduate teacher with a higher scale and a graduate teacher with a lower scale, Lordship. So, Lordship, when the old rule is repealed, Lordship, before the appointment of the petitioners, then the new rule has to apply. So under the new rule, a fresh graduate teacher scale of pay is mentioned. So we gave that scale of pay.
In support of that submission, do you have any citation?
Lordship, I have 2021 6 SCC 163.
2021 6.
SCC 163.
SCC
163.
163.
Yes.
Para?
Lordship, here, para 10th, 11th, then 15, 17, 29, and 30.
10, 11?
Lordship, 10, 11, 15, 17,
18?
17, then 29, 30.
No, volume 6. Volume 6 is 11.
Lordship, I will read the para 29. Here also, when advertisement was issued, a new rule came into force.
Just wait.
Yes.
The wrong citation.
2021 6 SCC.
Twenty 6 SC 163.
Yes, Lordship.
They've given us the wrong citation. Can you read?
Lordship, para 29. This court holds to be unmerited the arguments of the appellant that the stake was bound by the criteria specified in the advertisement issued by it in March 2016. Even though Clause 7 of that notification clearly specified that the recruitment for A&Ms would be in accordance with the statutory rules. The omission to mention the relevant qualification, that is intermediate or equivalent qualification with the science stream, did not relieve the stake from its obligation to follow existing rules. It has not been disputed that the 1997 rules, after amendment in 1998, mandated that candidates desirous of being recruited as A&M or health workers had to possess educational qualification including intermediate pass or its equivalent with the science stream, apart from the necessary A&M certificate course. That condition remained unchanged even after the creation of the state of Uttarakhand. It was only in 2016, after the advertisement for the recruitment concern was published, that the rules were changed. The new rules relieved the requirement of having to qualify the intermediate level with science subject for the period 2010 to 2013. And thereafter, after July 2016, for all other periods, the basic educational qualifications of intermediate or equivalent pass with a mandatory science stream qualification remain an essential condition. Therefore, the argument that the state was bound by the standard it specified in the advertisement, which had omitted any mention as to the educational qualification of the intermediate with science, did not relieve the state from the obligation of enforcing statutory rules. So, Your Lordship, what the petitioner is saying is that whatever is condition is mentioned in the advertisement, we are bound and we have to follow that advertisement. But by the coming into force of the new rule, what the Supreme Court says is that we are not bound by the condition of the advertisement, but we are bound to enforce the statutory rules, Lordship.
Well, Lordship, here, if I may be allowed to draw a distinction here. Now, there it is to stick to the rules. Here we are not, the advertisement was not issued against the rules. The issue there and here is it's completely different, Lordship. The advertisement was issued as per the old rules.
Yes.
So, Lordship,
Here also,
since it is as per the rules, now if we may appreciate the Honorable Supreme Court's judgment, in this case, now to enforce the new rule, Lordship, that advertisement, because the appointment order was yet to be issued, that could have been recalled. And a fresh advertisement could have been issued, recalling the old advertisement and calling for a fresh recruitment process, Lordship. That's a clear distinction
Lordship,
between
if that is the case, whether the
judgment referred by
petitioner
my
is
learned
now
friend.
willing to, for us to recall their appointment order and to publish whether they are
That is no more
agreeable.
open to
If
the
that
state
is
respondents,
so,
my
then we
lords are
can
fully
go with
aware,
that.
Lordship.
Joshua, Mr. Joshua,
Yes.
don't swallow your own words.
No, Lordship. Now that is, they are asking for something which is impossible, Lordship. They could have done that. They have not done it. How can they ask for that liberty now, my lords? And if my lords may kindly appreciate, all those who were appointed under the rules of 2002, they were not only as per the advertisement, Lordship, all those who were appointed under the existing rule at that point of time, that is the rules of 2002, they were appointed by paying the pay matrix level 10, Lordship. Here we're not even, this is not even an issue on qualification, it is on pay, Lordship. They're all being paid under the old rule, that is pay matrix 10, level 10, Lordship. And the advertisement, before your Lordship,
But
did
you
the
were
argument,
given,
Lordship?
pay matrix 9.
Yes, now the new rule is pay matrix level 9, Lordship.
Only.
Then you have to challenge the rules.
No, Lordship. That is not the issue here, Lordship. The advertisement was issued.
No, if you are sticking to this point, which you are just submitted.
No, Lordship. As
Why-
per the
why
old
not?
rules.
If you are still sticking to this point, saying that actually previously, under the old rules, the teachers were paid equally, uniformly. If you are sticking to that, but the new rules has actually created a classification. If you are actually sticking to that, then
No,
you will have
Lordship.
to challenge the rules.
As far as our case is concerned, Lordship, the advertisement was issued as per the old rules. Now, my Lord, if the observation made by the Honorable Supreme Court is to be appreciated by this Honorable Court, new rule came into being before the appointment order was issued. So the Honorable Supreme Court says that advertisement could have been recalled because it is as per the old rules. That could have been recalled, which has not been done, Lordship.
Lordship, we have
So, my
to.
Lord, an equal play field, Lordship, has to be appreciated by appreciating the judgment of the Honorable Supreme Court, in my respectful submission, Lordship. And in that sense, to challenge the new rule, the issue doesn't arise, Lordship. It is for for those who are appointed under the new rules after us. They should challenge the old rules, but the same is not applicable in our case, lordships.
Lordship, yes.
Yes.
I think, okay, the matter will again be heard tomorrow. Please come with proper citations in detail. Okay? Tomorrow?
Especially on the issue which this court
Yes.
has emphasized.
Yes. Otherwise, Your Lordship, what my learned friend are relying on the judgment is only with regard to the amended service rule. But here in this case, it's not an amended service rule. It is the enforcement of a totally new rules where the old rule was repealed. Yes.
Lordship, this is not an old department, Lordship. Even if the word amendment is not used, Lordship, it's a continuing service.
Mr. Joshua, you also properly go through the judgment recited by the learned additional AG, and if you
My lord.
find that there is any distinctive feature,
Your Lordship.
please address.
I will, Lordships.
Yes.
Heard both says, hearing remain unconcluded, list tomorrow. Tomorrow is
Tomorrow is
second of March.
second, yes. Lordship, second.
Yes,
Yes.
tomorrow. Come with proper citations, sir.
Oblige, Your Lordships.
Any more?
That's all.